Open court.
We're on the record, Your Honor.
Thank you very much.
The Honorable Stamford Superior Court is now open and in session in this place. The Honorable Judge Tierney presiding. Good morning, Your Honor.
Morning, everyone.
Morning, Your Honor.
Matter assigned for a hearing for today's date on a remote basis is FST CV24 606-8671S, the Lattarullo LATTRULO Law Firm LLC versus Edward Wilson and Mary Wilson. Identification, please, by counsel who has appearance for each of those litigants.
Attorney Joseph Mulvey for the plaintiff, Your Honor.
Your Honor, good morning. Attorney Kevin Collins of Collins and Powers for the Wilson, who are on a separate screen than I am, but present.
Thank you. This matter has been assigned for a remote hearing, and the order of notice for the remote hearing for today's date notes by the clerk's notations pleading number 119, 125, and 126, and all pleadings related thereto. Previous notice for December 10th had a slightly different variation. Pleadings 125, 126, 127, 128, and all other pleadings related thereto. Essentially, pleadings 125 and 126 form the basis of this matter, and I'm going to review a number of items relating to my review of the status of the trial docket in the Stamford Superior Court, both in the Stamford Superior Court civil side, Stamford Superior Court family side, and the Stamford Superior Court housing session. I will do so that there is a misunderstanding by me as to the matters that are of record. Counsel can freely make the comments, and we can deal with those on a direct basis without the need to formally offer evidence in that regard. I would consider each and every single one of those matters. The underlying order that brings us to court today is the order dated April 15, 2025, entered by Colleen Zingaro, Judge of the Superior Court. And the title of the order is Judgment After Completed Trial to the Court, a Hearing in Damages as against the defendants, Edward Wilson and Mary Wilson, in favor of the plaintiff, the Lattarullo Law Firm, LLC. The amount due on the claim was $8,385.06, according to Judge Zingaro's judgment. Reasonable attorney's fees, $3,262.50 in addition. Plaintiff's cost, $489. Total amount of judgment, $12,136.56. Quote, the judgment is rendered for the plaintiff, and the defendants named above must pay the total of the judgment and cost to the plaintiff as follows. No payment schedule was set forth in that particular order. It remains blank thereafter. The following is the last paragraph of the order. The court orders the defendant to pay post-judgment interest at the rate of 8%. That remains the judgment of the court. That is pleading number 117. The three aforementioned pleadings that I have just indicated on the Info 1 screen that is assigned by the clerk for today's date are 119, 125, and 126 are respectively a motion to open the judgment, a motion for periodic payments, and another motion for protective order 126. Pleading number 119 is the motion to open the judgment that was prepared by Attorney Collins on the JD 107 form, in which he indicates that there is a reason for the opening of the judgment, Judge Zingaro's judgment that I have just indicated, and he sets forth the reasons for that. That motion was dated April 30th, 2025, and it was marked as pleading number 119. An objection to that, the motion to open the judgment, was filed by the plaintiffs in a narrative fashion on May 16th, 2025, an extensive pleading of 14 pages in length under Mr. Mulvey's signature for the plaintiff, the Lattarullo Law Firm, LLC. That matter was submitted to the court. Both 119 and 120 was submitted to the court, and Judge Lee entered an order on June 6, 2025, and the June 6th order states as follows. The defendant's motion to open the judgment entered against them on April 21, 2025 is denied. The motion fails to comply with both General Statutes Section 52-212 and Practice Book Section 17-43 because the defendants have failed to establish by reasonable cause that they were prevented by mistake, accident, or other reasonable cause from timely objecting to plaintiff's claim or participating in the hearing and damages or objecting to the entry of judgment. Further, they have made no showing of any defense to the plaintiff's claim. The order states denied. That order was filed under pleading number 120, which is the objection. I guess it should have been filed under pleading 119, but since 119 did not have an order, I ordered the clerk to make sure that 119 was before the court. So if anyone has any concerns about the fact that Judge Lee acted on pleading number 119 but didn't enter an order under that number, but entered an order on the number of the motion that was the objection 120. A very common occurrence, and both lawyers are experienced and no doubt have seen that in their own private practice and surely have seen it in examination of the dockets. And that's the reason why pleading number 119 was added for the docket for today. The two motions that are the substance of the heart of the matter that's before today is a motion for order of payments, pleading number 125, and the protective order, pleading number 126, and any objections and motions that are related thereto, without delineating those particular numbers or documents. Counsel can refer those to me. I'm not going to make mention of it. I entered two orders on both of those motions. Those orders still remain in effect, and therefore the fourth subject, 119, 125, 126, the fourth subject that is before the court today is how to deal with these two orders, September 19th, 2025. Orders state as follows, quote, the status conference scheduled by this court concluded on the morning of September 19th, 2025. A remote hearing will be scheduled on motions 125 and 126. The court enters the following stay order effective September 19th, 2025. After reviewing this file and the underlying eviction file, the court wishes to bring the collection process to a halt until this court can hold the appropriate statutory hearing on motions 125 and 126. No further evidence for the collection or enforcement of this judgment will occur until the conclusion of that statutory hearing. That identical order was entered in both motions number 125 and 126 and remain in effect. Therefore, the court has entered an order preventing any further collection efforts by Attorney Mulvey, and there's no indication in the file that any of those orders have been violated, and any concerns about the violation are not before the court for today. The court did hold a status conference prior to that date and then entered the orders thereafter. The court no doubt entered those orders at the status conference, but followed up with the August date thereafter. There is an objection to a weekly order of payments. There's some research that I have done on the matter, but in reviewing this particular file, it appears that the pleadings in this collection case are extensive. Last pleading is 132 for an ordinary collection case. That's a large number of pleadings. The court is familiar with those pleadings and has reviewed the file. The problem with this court reviewing the file in this particular family litigation, that is not a complete review of the file because the file is not just docket number FST CV 24-606-8671S, but it is a myriad of litigations filed in a number of different courts around the state of Connecticut. And I have attempted to review each and every single one of those files in preparation for today. The first file that I have reviewed is the eviction file. That is the appearance filed for Donna Latarula on behalf of the Latarula Law Firm LLC, representing Edward and Mary Wilson in that litigation. And that litigation concluded after a motion practice requiring preparation and research and appearance in the housing session dealing with various motions. It required the litigation preparation because the matter was tried in a contested fashion. So that was the second component. And the third, it dealt with the matters in the trial court by reason of the appeals that were taken by Mr. Lindenthal in the eviction action for the property in Wilton, Connecticut. In addition to those matters, as the appearance of Donna Latarula in the underlying eviction case. The eviction case was upheld. She filed the eviction. She obtained a judgment, and she was able to have that judgment capable of being enforced. The two appeals were both reviewed by the trial court, and a motion to dismiss was filed after a number of pleadings in the appellate court for both of those appeals. And Judge Spader, who was sitting as the housing assignment judge, had the last motion that was filed in both of those appellate documents. I've reviewed both of those motions, and the motions were addressed and filed by Donna Latarula on her behalf of the Wilsons, and those two motions were granted, dismissing the two appeals, and the appeals were dismissed on a factual finding. Judge Spader was of the position that the Lindenthals were no longer in occupancy of the property, that whatever facilities that had been utilized for dog businesses no longer was in operation at the property, and therefore there was no reason for the eviction, which had to do with possessory rights of the property. That no longer was at issue. Therefore, the appeal would have accomplished nothing. The appeal was therefore dismissed as moot, and both appeals were dismissed as moot in that regard. So Ms. Latarula was successful in obtaining the results in the underlying eviction case, the various motions that were heard in the eviction case, as well as the trial and the enforcement of the eviction order thereafter, as well as seeing that the two appeals were properly prosecuted from the defendant's point of view and were appropriately dismissed by the judge. She made those arrangements in that regard. In addition, this matter involves a family relationship. There was a marital relationship between the occupant, Mr. Daniel Lindenthal, or was a relationship between the occupant, Daniel Lindenthal, and his wife, related to the Wilsons. And the real property was at issue at an address at 157 Cheese Spring Road in Wilton, Connecticut. The real property at 157 Cheese Spring Road, Wilton, Connecticut, formed the basis of this eviction action. That was the premises in question, formed the basis of the two appeals. Those are the premises in question. It formed the basis of litigation in the dissolution of marriage action by Daniel Lindenthal. It formed the basis of their separation agreement and the division of any proceeds from the sale and or occupancy rights of 157 that were shared by the separation agreement. And there was no sale. So I assume that there was no payment that was made in accordance with the separation agreement. I saw nothing within the dissolution file to indicate that there was any contesting of any monies that was being paid. I have no idea of any monies that had been paid on a private basis, but none found their way into the litigation in the court file. I have not reviewed each and every pleading in the eviction litigation, but I have looked at each pleading. Reviewed pleading means I've read every word. That's not so, but I have a great deal of familiarity with the housing session. I presided over the housing session for over 2 years, in my previous assignments. And I have a familiarity with the family litigation, but then I have not looked at every single motion, but I have looked at the separation agreement. I looked at the terms of the separation agreement. I saw the nature of what the litigation was and the real property issues. And I also looked at the financial affidavits that were last filed in the litigation concerning any claims that they had made concerning real estate and the property at 157 G Spring Road in Wilton, Connecticut. And I was familiar with each and every single one of those items. In addition, there was litigation between the Wilsons and Daniel Lindenthal. I believe that there were two forms of litigation. The first form of litigation was a claim that Mr. Lindenthal and his wife had paid a sum of money toward the purchase of the property at G Spring Road. A sum, I believe, if my recollection is correct, within the range of $180,000, and that he was looking for a benefit of that, and that litigation was not fully prosecuted and has terminated without any judgment. There was a private matter. That matter happened to have been assigned to me for trial. I was the assigned trial judge, so I had done full preparation of that particular case. It appeared on my docket. 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 And eventually the matter was disposed of, a very common occurrence in litigation. Judge ready to try the case puts a fair amount of pressure on the parties to come to a reasonable solution, and that's what occurred to the satisfaction of this court. In addition, there was litigation over what was claimed to be a mechanic's lien. And there was a lawsuit filed over the foreclosure of the mechanic's lien. And there was a separate lawsuit filed by the Wilsons on the basis of the mechanic's lien, and they were seeking to discharge the mechanic's lien. And those two matters all had resolved themselves. So, summing up, Donna Lattarula, the Lattarula law firm, was hired for an eviction case, and she has not been paid for her attorney's fees, in which she did a preparation for the case, filed motions and opposed motions successfully, tried the case successfully, and prosecuted the case to a favorable conclusion, defended the litigation results in two separate appeals, which she caused them to be dismissed, and she is looking for attorney's fees at this particular point. The issue of whether or not there is any defense to the case has been litigated, and Judge Lee has decided that there is no defense to the case, and the issue is whether or not there are periodic payments. I'm assuming that Donna Lattarula, at the time that she filed an appearance and that she had the retainer signed, which is in evidence in this particular collection case, knew the family history that I have just recited. If I have made a mistake or error, or I've missed the family history, I apologize, but this is not a simple matter. It's not a simple collection case. It's not a simple motion for a court to make a determination of payments. There is a background information, and I have spread that on the record for the purpose of indicating that's what the record shows, to at least expose that if I have made a mistake, for someone to correct me for the mistake, and to prevent the need for offering all of that evidence at the hearing for today. With that as a statement, I have nothing further on a administrative matter. I have reviewed the files, and it appears that although I have written down pleading number 119, that the only deficiency in pleading number 119 was that the order entered by Judge Lee was only transposed and placed in pleading number 120, and should also be placed in pleading number 119. And there is no need for any further hearing on motion number 119, which is the motion to open the judgment, and the pleadings 125 and 126 form the basis of the argument and decision to be rendered in this case today. With that, I would like to hear from the court concerning the transposing of Judge Lee's order from pleading number 120, where it will remain, and adding it to pleading number 119. Those are my preliminary statements.
Your Honor, are you inviting a response
I am.
on the issue of the transposition of that Judge Lee's decision? That is certainly not something to which we object. So that is not an issue for us as the defendant. The other thing I would say is with regard to Your Honor's statements and comments, if I heard correctly, I think I heard Your Honor say that Attorney Lattarulo's firm had not been paid, but that is, if that is what Your Honor said, that is not an accurate
No,
observation.
I purposely did not go through the amount because it was a moving target when I went through the numbers to find out exactly what the numbers were. There had been payments prior to Judge Zingaro's decision. I believe that there had been a $5,000 payment. I saw some notes in that particular regard, so I stand open to any information about any payments that have been made.
Well, my point would be this, Your Honor, that there were substantial payments in part that Your Honor reflects the $5,000. And I think there were additional payments which came via the fact that Mr. Lindenthal was paying the rents into escrow and that Attorney Lattarulo was able to collect certain fees from those funds. That having
Your Honor,
been said,
I object to this. This is beyond the scope of this litigation and hearing. Those are things that have happened in the past. This hearing today is about when and how and if the judgment is going to be paid. Any past things are an historical record, but they have no bearing on where we are today.
Overruled.
so Your Honor, to that
Their
point,
consideration for me.
and to that point, Your Honor, and it as I was about to say before the objection was, it may not affect the amount of the judgment here, but it is. I don't want the court to have the impression that Attorney Lattarulo was not paid substantial fees, which he was. To be clear, I think this court would view this case differently if Attorney Lattarulo had been paid very little or no fees. The reality is that she was paid substantial fees, and this is the balance that she claims is due. I think that's important for the court to consider.
Yes, okay. All right. So to the point 119, you'd have no objection to 119 being the clerk just putting that order 120.01 and adding that order to 119 as order number 119.01.
Defendant does not object, Your Honor.
Okay, thank you. Let me just, I'm going to go off the record for you. I'm going to speak to the clerk. I've just given the clerk a copy of those two documents, if you would, please. Thank you. I just had a meeting with the clerk who's just sitting here next to me, and we have no further questions. Okay. With that, the moving party, Mr. Collins, I believe, any administrative matters that you wish to bring to the court's attention before we start having a hearing on 125 and 126 and related pleadings?
No administrative claims, Your Honor.
Thank you, Mr. Mulvey.
So None, Your Honor.
Thank you very much. Okay, ready for the hearing.
Thank you, Your Honor. I have the Wilsons on the screen. I would ask first to call Mr. Wilson to the stand, and then I will call Mrs. Wilson to the stand. They've not been yet sworn.
Thank you. You have a screen?
Yeah,
Yes.
would you like me to swear them in?
Yes, please, place Mr. Wilson under oath, please.
Can you please raise your right hand? Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case will be the truth, the whole truth, and nothing but the truth, so help you God or upon penalty of perjury?
I do.
Can you please state your name, spell your last name, and state your address for the record?
Edward W. Wilson, Wilson, 12 Pleasant Street, Darien, Connecticut, 06820.
Thank you.
Shall I proceed, Your Honor?
Thank you.
Mr. Wilson, good morning.
Good morning.
Wilson, how old are you, sir?
80 years old.
80. And are you presently employed, sir?
No, I am not.
When was the last time you were employed?
I would have to say sometime around the age of 73, and that was part-time as a consultant. I'm a retired school psychologist, and my last employment was with the Bridgeport, Connecticut public school system.
So that would be approximately 7 years ago. Is that correct, sir?
Yes.
Okay. Do you have any source of income or sources of income?
Yes, I have pension and I have Social Security.
How much do you get on a monthly basis from Social Security?
I'm going to say approximately $2,300.
That's per month.
And that's per month.
Yes,
And is your pension in pay status? In other words, are you receiving payments from the pension?
yes, I am.
And how much do you get from the pension, sir?
Approximately, I'm going to say a little under $6,000 for my pension.
Okay. The two monthly payments that you just gave me, sir, are those gross payments before taxes?
Excuse me, I don't understand the 2 monthly payments.
Social Security and retirement. Right at Bridgeport and I have New York City.
Hold on. You have a pension that pays you something under $6,000 a month. Is that correct, sir?
All right. I have to clarify, I have two pensions, one from the city of New York and a second pension through the state because of 10 years of Connecticut employment.
Okay. And as I asked you a moment ago, do you receive payments on a monthly basis for both pensions?
Yes, I do.
Excuse me, hold it. You did not ask that question. He just said 6,000. He didn't indicate the period of time for which the 6,000 was paid. And that's the reason why I raised the question. I do not know what he's saying.
So when did you start receiving the roughly $6,000 a month?
No, he has not testified as to what the 6,000 is. He just said 6,000.
I'm confused, Your Honor. I apologize.
I'm sorry. I know that you're asking questions, and you have two jobs. You are asking questions, and then you have to listen. My job is listening, so I have an easier job than you do, Mr. Collins. Okay. Okay. Mr. Wilson indicated his monthly Social Security, clearly stated monthly. When he said 6,000, that was the first time that he used 6,000. He did not indicate the term for which 6,000 was paid.
Understood.
It's
Now I understand.
not per day, per week, per month, per year, per quarter. He was silent in that regard. You've asked questions, having put per month in there, but Mr. Wilson has not testified as to that. That's the reason for it. He just said 6,000.
Understood. I got it. So, Mr. Wilson, when you say that your pensions are in pay status and you receive $6,000 or something slightly less than that, how frequently do you receive $6,000?
All right. Once
It's-
monthly, sir.
Got it. So monthly. So you have Social Security monthly, about $2,300 a month, and you have two pensions which pay you in the aggregate something slightly less than $6,000 a month. Is that correct?
That is for, yes,
Okay. And are taxes taken out of the Social Security, sir?
yes, they are.
And are taxes taken out of your monthly pension payments?
Yes, they are.
Okay. Other than those two sources of income, do you have any other sources of income?
Occasional, payments on annuities, which would be totally a few $100s, a few $100 during the course of the year. I'm going to say approximately $500 or $600 during the course of the year.
Meaning over a 12-month period, sir?
Yes, that's correct.
Okay. So if it's $500, it's less than $50 a month. Is that a fair statement?
I would say that's approximate, yes.
Okay. Now, sir, also with regard to this, you own a home in Darien, Connecticut. Is that right?
Well, we own the home, but the bank has a mortgage of approximately $368,000.
Okay. And when did you purchase this property, sir?
Property was purchased in November of 1972.
Okay. So you've been there for approximately 53 to 54 years. Is that correct, sir?
Yes.
Okay. And you just alluded to a mortgage of $368,000. When did you borrow those funds?
Oh, the funds were borrowed. I cannot give, I'm going to say more than between a range of approximately 15 to 20 years. I can't give you an exact date at this particular time. It's an
You make
approximate.
payments. You make payments on a monthly basis on the mortgage, sir.
Yes, approximately payments vary. Monthly payments vary from anywhere from $2,100 to $2,300 monthly. They're paid to M&T Bank.
Okay. Are you current, sir?
Yes.
Okay. Now, sir, your wife is sitting next to you. She's not
Hold it,
testifying.
hold it. He's current in the mortgage. Is that your point?
It is my point, Your Honor. But also my second point is his obligation is anywhere between $2,100 and $2,300 per month.
Okay, I'm just, current means he's current with his payments. If you could ask him that, please.
I will. Are you current with your payments on the mortgage, sir? In other words, are you in arrears on the mortgage?
No. Monthly is payment, and we're paying off interest only.
Okay.
Nothing toward the principal.
Okay. As I said a moment ago, you're sitting there next to your wife. She's the other defendant in this matter. Is that correct, sir?
Yes.
You live in the property with her.
Yes.
You live in the property with any other persons.
My older daughter and her two children, who are also my grandchildren.
Okay.
Our
And
grandchildren.
when you say your older daughter, was she the person who was married to Daniel Lindenthal?
Yes.
Okay. And the two children that live with you, how old are they, sir?
Just one is the 14, and how old's it?
13 and 9.
13 and 9. The girl is 9 years old, and the boy is 13 years old.
Okay. And the boy is DJ, is that correct, sir?
Correct.
And the girl is Aubrey?
Yes.
Okay. So does your daughter, Melissa, contribute toward any of the household expenses?
At this time, no.
Okay. Do you support Melissa and your two grandchildren through whatever income and your wife may have? And I'll be asking her about hers later.
We carry all of the charges for the home, for living in the home, including utilities, taxes, mortgage, interest, any other related charges to the maintenance of the home, including the maintenance and including insurance coverages. We
Right,
also,
My
I'm sorry.
question had to do with your daughter and the children. Do you support them financially?
yes,
And understanding that they are the beneficiaries of you paying for the house and the utilities and so forth? Do you pay for food?
yes,
Do you carry an automobile for Melissa to drive?
yes,
Okay. And do you provide services? Do you babysit the children?
yes, we provide care, yes.
We just had Christmas. How did the children get gifts?
Yes,
Who bought the gifts?
we did. Mary Jane and Edward Wilson
And
purchased the
sir, with regard to and Judge Tierney has indicated he reviewed the family file. There is an order in the family file that Melissa is to receive child support for the two children. Are you aware of that, sir?
I've
That
heard
there's
that.
an order.
Okay, yes.
Okay. To your knowledge and information, has Mr. Lindenthal paid child support, or is he paying child support to Melissa for support of the two children?
Your Honor, objection to this line of questioning. It's really outside the scope of this hearing.
Why is it outside the scope?
Well, he's actually, bringing in something that has no bearing on this case. It's a voluntary payment, obviously, that they're making, but that's my objection.
Overruled.
So, to your knowledge, I don't know if I got an answer yet, sir, but to your knowledge, is Mr. Lindenthal paying, or has he been paying child support for the support of his two children?
Not to my knowledge.
Okay. Sir, do you have any other expenses other than the house and your I'm going to withdraw that.
Have you finished the discussion of the separation agreement?
Yes, at the moment, yes. I believe I have, Your Honor.
I didn't read exactly all the terms and conditions, but there was also a $500 a month alimony payment.
Yes, my
There
mistake.
was,
Thank
oh.
you.
Okay.
Mr. Wilson, are you aware that Mr. Lindenthal was to pay $500 per month for alimony to your daughter Melissa from the judgment?
No, I was not aware of it.
To your
I was
knowledge
not
and
made aware of
information,
it, no.
to your knowledge and information, is Melissa receiving, or has she been receiving, alimony payments from Mr. Lindenthal?
Not to my knowledge.
Okay. And again, she is not contributing in any financial manner to the household or to the upbringing of her children. Is that a fair statement, sir?
Yes,
Okay. Sir, the house on Cheese Springs sold, is that correct?
yes,
And Mr. Lindenthal did everything in his power to stay in that property, didn't he, sir?
yes,
And that is why Attorney Lattarulo had to perform services as His Honor articulated them this morning. Is that correct?
yes.
Okay. And did Mr. Lindenthal's actions cause you any financial detriment other than the legal fees that you had to pay?
Yes.
Okay. What other financial detriment did Mr. Lindenthal's actions bring to you, sir?
Mr. Lindenthal took, with my knowledge, and I signed for them, he purchased several vehicles, including trucks, Chevrolets, and BMWs. And I was the co-signer. Mr. Lindenthal defaulted on these vehicles, on several of them, with the exception of maybe one. During the time that Mr. Lindenthal occupied the home. He paid for a period of approximately 6 years. Mr. Lindenthal only paid 2 monthly rents. The rest was
Excuse
carried
me,
by
when you-
myself and
excuse
my
me.
wife. Yes,
Excuse
sir.
me. Cheese Spring. When you say home, that was Cheese Spring?
Yes,
Thank you.
yes, the home in Cheese Spring, it's home on Cheese Spring in Wilton, Connecticut. Yes, Your Honor.
Thank you.
Has what he has done with regard to the vehicles caused you great financial detriment?
It damaged my credit rating. And there are a couple of instances, several instances
But Your
where I
Honor, I
had,
object to that question. It's leading.
He's answered the question.
all right.
Next
In
question,
what,
please.
in what way has Mr. Lindenthal's behavior with regard to the vehicles caused you financial detriment?
Because I was obligated on 2 occasions to pay the outstanding payments due on the loan. I needed that to negotiate a HELOC, a home equity line of credit with M&T Bank. I had to pay off 1 or 2 debts on BMWs on cars. My credit was going to the from fair to good. Actually, it was fair. I had to rely on my wife's credit history to even make certain purchases like at Home Depot and department stores. So yes,
All right.
there was, yeah.
All right. And sir, Cheese Spring Road ultimately sold after probably a couple of years of attempts to get Mr. Lindenthal out. Is that a fair statement?
Yes, it is.
And you did receive some money from that sale. Is that correct, sir?
Yes.
Do you know how much you received after all was said and done?
I can't give you an exact dollar amount.
Where did the money go?
The money went to pay off expenses and the sale. Mary Jane and I, my wife and I, owned Cheese Spring, and the proceeds from the sale of Cheese Spring in Wilton went to us.
And what did you do with the money?
We made substantial, well, first of all, we paid taxes, and we're still paying, I'm still paying estimated taxes. Also, we paid off, paying off taxes, trying to minimize debts, credit card debts that we had to incur, along with trying to make additional payments on the HELOC. The $368,000, the existing 368 on the HELOC is intimidating because, as you pointed out, I'm an 80-year-old man and my wife is in her late 70s.
Was the credit card debt a result of Mr. Lindenthal and your dealings with him?
Yes.
How so, sir?
Mayor, I'm going to object to this line. This is irrelevant. I mean, it doesn't. Why is this payment any different than any other credit card payment? I don't understand that. It just seems prejudicial and irrelevant.
The motion before the court is a motion to set a periodic payment. Requirements for the determination by the court in making the determination as to the periodic payments are equitable and are not limited in scope. So the objection is overruled because of that.
So, sir, my question of you was, did the credit card debt result from Mr. Lindenthal's actions?
Yes, we had to play out on a credit card. We had to use our credit cards to pay off existing debts and make payments on necessities because the lack of a consistent monthly rent did not contribute to our cash flow. It limited our cash flow.
And Mr. Lindenthal, was he obligated to pay rent? You alluded to this a few moments ago, that he only paid like maybe the first 2 months' rent.
That's all he paid. Correct.
And you had, sir, what condition did Mr. Lindenthal leave the property in when he finally vacated?
The property needed both interior and exterior care. Landscaping, there was an incomplete patio on the land with pieces of bluestone or slate. These had to be, in order to make the house saleable, we had to purchase the new patio. We had to purchase doors for the home. There were other painting, extensive cleaning. I'm really sorry to say that it was left in almost like, I'm going to use the expression, and may hope the court begs my pardon, but the place was left like a pigsty. Mr. Lindenthal kept dogs in the basement in cages.
He didn't keep,
There was-
he didn't keep any other animals there besides dogs? Is that what you're telling me?
I think there was a cat or two.
Okay. But no
Maggie-
pigs, no pigs. Is that correct?
No, no pigs.
Okay.
It was,
Would you
he
say-
was running it appeared to be a kennel. That was his business. It was a kennel. And the basement not only had to be cleaned, it had to be sanitized, disinfected. And there were questions about sanitation issues in the basement. I was concerned for the health, not just for our health, but also for at that time grandchildren who were living there. And then after they left the home to come to live with us in Darien, I was concerned, and rightfully so. I did get I'm going to say it was air purifier, a remediation firm to come in and to clean up to look for black mold, to look for any molds, any dangerous, any dangerous bacteria that might have been left behind. There were animal feces, which, as you know, produce some terrible illnesses and diseases, or can cause some terrible illnesses and disease and create diseases.
Mr. Wilson, do you continue to suffer financial detriment as a result of all these things at this moment and going forward?
Yes, I'm concerned. I'm concerned about our financial stability.
And you are supporting, you and your wife, you, herself, and 3 other people, including 2 minor children, correct, sir?
That is correct.
And you are the sole source of support for your daughter and her 2 minor
Excuse me,
children. Is that
two
correct?
minor grandchildren.
2 minor grandchildren, yes.
Thank you.
Is that
He
correct,
He
sir?
doesn't have any, I don't know about how many children he has.
Oh, you have 2 children, correct, sir?
That is correct.
That
And
that
they're
would be
not
Melissa?
minors.
No, they're not minors, right?
No,
And you have, and your daughter is also Attorney Powers, my partner. Isn't that correct, sir?
that is correct.
Okay. So, Mr. Wilson, is there anything you would like to add about your ability to pay roughly $12,000 in a lump sum or in substantial incremental payments here?
It will be financially stressed to pay that amount immediately in total. No, It's not doable. It's not possible, sir.
And will it impact your ability to support your family, including your daughter and the two children?
Absolutely, yes.
Okay. If I have a moment, Your Honor.
Thank you.
You have any money in the bank, sir?
Yes, I do.
Okay. Do you have any idea how much money you have in the bank?
At the moment, we have a savings account of approximately $9,000.
Okay. And do you sometimes have to raid your savings to make ends meet?
Your Honor, it's leading. I object.
It is leading.
Okay. Do you ever have to, with regard to the savings, what do you do with it, sir?
Pay bills.
Okay.
And try to
Nothing
put our
for-
head on the pillow at night.
I have nothing further of this witness, Your Honor.
May I inquire then, Your Honor?
You may.
Thank you. Mr. Wilson, you testified that you sold Chief Spring Road. Is that correct?
Yes,
When was that?
all right. Within the past, I believe, we sold it in early 2024.
It was your testimony. You don't have any personal recollection of what you sold the house for and what you netted from the sale. Is that correct?
I don't have that at my fingertips, sir.
Okay. Now, did you knew that you were coming to this hearing today, correct?
Yes,
Okay. Now, what documents did you review to prepare for this hearing?
I didn't know the scope of this hearing. Excuse me, I'm not an attorney, I'm not an accountant. I'm a retired school psychologist. I do not have your expertise or experience.
Your Honor, I asked that be stricken as non-responsive. The question was, what documents did you review in preparation for this hearing?
You have that preparation.
All right. First of all,
No,
I don't
Mr. Mulvey,
Yes, Your Honor.
it's more effective to ask the next two questions. Is there anything further that you wish to say in response to that question? And then furthermore, do you recall what the question was? Right?
Thank you, Your Honor.
And the point is very well taken. And then you re-ask the same question. You can, with a jury, you wouldn't do it more than 3 times. They'd get mad at you. Okay? So
Thank you.
re-ask the question then.
All right. Mr. Wilson, before you today, did you review any documents to prepare for this hearing?
No, just no. No,
Then
excuse me.
Excuse me, please, hold it.
Yeah.
The recording has to be made with only one person speaking. There's some background noise. If we have mechanical devices, then we have to shut off all mechanical devices and re-engage, and then that will eliminate any duplicate noise if that's where the noise is coming from. Next question, Mr. Mulvey, please.
Okay. Why did you not review any documents prior to this hearing?
objection, Your Honor, relevance.
Overruled. You may answer the question, Mr. Wilson.
I had no idea, my wife and I had no idea of the kinds of questions we were going to be asked. And not knowing that, there was no way that I could, no way that I could prepare for or anticipate any of your questions or the court's questions. That is my answer.
Okay. As to the Chief Spring Road, do you have any remembrance of what range the property sold for?
No, at this particular time, and I'm not going to guess. I
Did you
can't guess. I don't have the numbers at my fingertip. I want to answer you honestly and I want to answer the court honestly and intelligently. I need information. before I answer questions.
Mr. Wilson, did you have the property listed with a realtor?
Yes,
What was the property listed for?
I don't remember the exact amounts.
Okay. Was the Chief Spring Road property, did you consider that a major asset of yours?
You object to the form of the question, Your Honor?
Not argumentative. I'll allow it.
The purchase of the Cheese Spring property was in no way a source of income to us. It was a financial burden.
Okay, I'm going to re-ask the question. Did you consider Chief Spring Road a major asset to you?
No,
So why is that?
because we were not receiving any rent for the property. It was not an income producing property. Actually, it required payments, mortgage payments, which included taxes. It also included responsibility for maintaining and also maintaining, I call it maintenance and protection of the home, which is the upkeep, repairs, and also carrying insurance policies.
Okay. So, are you saying that when the Chief Spring property sold, you experienced a financial loss?
Yes, over the course of the years that we owned the home, that my wife and I owned that home.
So what was the total loss that you incurred for owning and selling Chief Spring Road?
I'd have to go back and look at taxes in it and talk with my accountants.
Okay. When you sold Chief Spring Road, did you pay a capital gains tax?
Again,
Yeah, doing it now.
well, we're paying, yes, and we're still paying taxes. We're paying estimated taxes to both monthly and also estimated taxes monthly and quarterly to both the federal government and the state of Connecticut.
Okay, then what was the sum of the capital gains tax upon which you had to pay the government?
I bet, would you please restate that, sir?
All right, so you testified that you had a capital gains when you sold Chief Spring Road, correct?
Yes.
Okay. So what was the sum of the capital gains that you received from the sale of Chief Spring Road?
I'd have to go back and look at any documents relating to the closing.
So you have no knowledge.
At this particular time, no, I cannot answer your question.
Okay. Now,
Mr. Mulvey,
yes,
are you aware that the first mortgage on the property at 157 Cheese Spring Road was to William Ravis Mortgage LLC?
no, I wasn't right.
So you didn't do the homework, did you? That's exactly what Mr. Wilson is saying.
Okay.
Were you aware that the first mortgage was in the amount of $534,375?
I believe I did look at, but I don't have any personal recollection of that today.
Were you aware that there was no foreclosure action ever brought by either William Ravis Mortgage LLC or any other entity against the Wilsons for
No,
the property at 157 Cheese Spring Road, Wilton, Connecticut?
No.
Okay.
I did
Do
do a
you
search to
have
see
any
if the,
knowledge, do you have any knowledge as to whether or not the deed from the Wilsons to whoever was the purchaser of 157 Cheese Spring Road, Wilton, Connecticut, would be on the internet, that you would be able to obtain at a 15-minute court recess?
I suppose so, Your Honor. I noticed that some sales are on the internet and others aren't. Depends on the town, the location, jurisdiction.
Okay. All right. I'm just saying that there are sources that are available that we can deal with that information if you're really interested in doing so. And I'd be willing to give you whatever time that's necessary to be able to obtain that information. That doesn't prevent you from making questions and answers and setting a record in the fashion that you wish. I'm not limiting you in that
Thank you.
regard. Okay?
Right, I may
Do you
ask for a
have
reason.
any idea, do you have any idea where I obtained this information that I just gave you about William Ravis and the $534,375?
I would hazard a guess, perhaps from the land records of the town.
Not
Or-
quite.
Or
Not quite. That's too deep a dive for.
or the just a basic internet search.
Thank you.
Before I ask for,
You may continue your examination, please.
Mr. Wilson, do you own any stocks?
Any stocks?
Yes.
Yes.
Okay. And which stocks do you own?
Some Apple. That's to the best of my recollection.
And do you have any knowledge of the estimated value of those stocks?
Oh, at this particular time, no, I do not.
Do you know how many shares you have?
How many shares I have? I'm going to say, no, I really can't. No, I do not.
What person or institution has custody of those shares, if you know?
Well, there would be two. One would be LPL Financial, that's associated with M&T Bank, which is my bank, and another Bright House, which is a company. Actually, it's an insurance company. It's associated or affiliated with Metropolitan Life. I obtained that when I was working here in Connecticut.
Okay.
I
Mr.
got
Ciulli,
involved with it. Yes.
do you have
Yes.
any money market funds?
No, no, sir.
Do you own any ETFs,
Which are?
electronic transmitted funds?
Do I own any? I don't understand your question, sir. I don't know what those are.
Okay. You testified before you had annuities. Who are the annuities with?
Well, they were purchased through MetLife. MetLife had a service that was available to employees in Bridgeport Public School System. And they offered financial opportunities for investments and funds, and I took advantage of that.
Okay. And what is your understanding of the face value of the annuity?
Non-existent.
Why is it non-existent?
I really don't keep up. I'm going to say this. I guess I'm revealing why I didn't study accounting and I turned towards psychology. I really don't have that background. I am not a financial person.
All right. Do you have any warrants?
Any what?
Warrants?
Warrants? What kind of warrants?
Your arrest.
For arrest? Oh, absolutely not.
No,
Hopefully,
no, I don't. Financial warrants.
Which would, in what? Please explain that to me, sir.
All right. I'll withdraw that question. Are you the beneficiary of any trust?
No.
Do you have any out-of-state bank accounts?
No.
Okay. Do you have any? How many bank accounts do you have in your name or in which you have any interest in?
Well, actually, one with my wife.
That would be the M&T Bank.
Correct.
So, do you have a checking account?
Yes,
And who is that with?
my wife.
Your wife is your checking account.
She is, both of us hold the same checking account.
Okay, so you have one savings account and one checking account. Is that correct?
Actually, yeah, yes, two checking accounts, yes.
Okay, where are the two checking accounts?
M&T Bank.
Okay, and do you have any personal knowledge of the what's held in those two checking accounts?
Right now, I'm going to say approximately maybe $5,000. That's an approximate amount.
Okay, and that would be in addition to the 9,000 that you testified early, correct?
Yes.
Is any other family member helping you maintain the house or your
No.
grandchildren?
Excuse me. I didn't let you. No, no one else. No.
Okay. Do you have any accounts with any credit union?
No.
Do you have any life insurance?
Yes.
And who is that with?
One is through the city of New York, and the other one is through the city of Bridgeport.
Okay. In the city of New York, what's the amount of that life insurance?
I'm going to say approximately $37,000.
Is that paid in full?
No, I
Well,
pay.
I'm going to
it's
object to the
monthly.
form of the question.
They're
I
a
think,
monthly
Attorney
payment.
Mullen, I'm going to object to the form of the question.
Sustained.
Thank you.
Okay. Is that a policy that you purchased?
Yes, I purchased that.
Okay. And what are the payments that you make on that every month?
I'm going to say it's approximately $177 monthly.
Okay. Do you know how much longer do you have to pay before the policy would be paid in full?
Well, I'm going to
I
object
can't-
to the, I'm going to object. There's no foundation. We haven't established what kind of a policy this is.
I asked you, said it was a life insurance policy.
That's not the point. My objection would be, is it a whole life or is it a term life?
Thank you.
That would
Thank
bear
you.
significant.
Thank you. I now have the idea, and you've given the proper objection to Mr. Mulvey. Sustained, please.
All right. I mean, do you know if it's a whole life policy?
I'm going to claim ignorance because I don't know the difference between a whole life policy and the other policy.
A term policy
I'm sorry,
would
sir,
only be
please.
for term policy would only be a limited number of years. You would purchase it and it would be in effect for 10, 20 years. And then at the end of that time, the policy would lapse. Does that help you?
You know, it sounds right.
So do you know if your policy is a term or a whole life?
No, no, sir, I do not.
And the other policy, do you know if that's a whole life policy or a term policy?
I'm not, again, I am not sure. I'd have to ask that question.
Okay, what's the value of that policy?
Well, there's one, $20,000. It's through the city of Bridgeport.
Is that policy paid up in full now?
No, it is not. No, it is not, sir.
What do you pay a month on that?
Approximately $13.
Okay. So you said you have you have credit, who are your credit cards with?
Oh, Citibank, M&T Bank,
Okay,
an Amex card, yes.
okay, with the Citibank, what is the limit on that card? Do you know?
Well, I think one is $30,000. The other one, I believe, is $75,000.
Okay, the one that's 30,000, who is that with?
Citibank,
And the
It's-
$70,000 one?
75, that's also with Citibank. They are MasterCard A Advantage cards. And then there's another one, it's a cashback.
Okay, have those cards been maxed out?
No, they have not.
Okay, do you know roughly what your current balance is on each card?
I'm going to say at this particular point on each card, no, I can't give you an each breakdown, but it's about, I'm going to say somewhere about approaching $5,000
For both of them
for all of them.
combined, together they're $5,000.
I'm between $5,000 and $6,000 approximately.
Okay, and then what do you purchase your food and gas with those credit cards?
As needed, yes.
Okay, and do you have any rough idea of how much you spend each month on food?
Well, my wife does most of the shop. She's sitting next to me and she can give you a better answer than I, if you want to direct the question to her.
So is it fair to say you don't know?
That's correct.
Okay, and how much do you anticipate you spend on gasoline?
Gasoline, I would say anywhere from I'm going to have to take a pass on that. I cannot give you an approximate amount, sir.
Do you know how much your fuel costs are for running your house every month?
We live in an all-electric house. My monthly payments to Eversource, my monthly payment is $750 monthly.
So that would include your heat, hot water, and electric?
Yes.
And do you pay for some sort of cable servers or streaming servers at your house?
Yes.
Okay, and how much do you spend on that every month?
Oh, I'm going to say approximately anywhere between $100 and $200 a month. Approximate.
All right. And then, do you and your wife own any real estate outside of the state of Connecticut?
Any real estate outside of the state of Connecticut? We own a timeshare
Oh,
with Hilton. And years ago, we purchased actually, it was a timeshare that we thought we would go to in Utah, but each year I am paying taxes, real estate taxes of approximately between $1,200 and $1,500 a year for an unused piece of property.
But have you tried to sell it?
That is on the table. We are thinking about that.
So you have not tried to sell it?
Not at the moment.
Attorney Mulvey, would you like it?
No.
I think you answered the question then too.
No. But okay. Other than that, do you have any other investments and with question what's wrong with Uh, if, other than the litigation that's been discussed in this pending hearing today, have you been involved with any other lawsuits within the last 5 years?
No,
Okay. Did you initially after you won the appeal in the underlying summary process case, is it true that you refused to pay my client what she when she invoiced you?
I'm going to object, Your Honor.
Sustained.
Relevance.
Sustained.
All right. Well, Mr. Wilson, did you file a grievance against my client?
Objection, Your Honor. Relevance.
I think it's relevant, Your Honor. I mean, the court indicated that this is an equitable hearing, and the court is considering all the background and everything else that got us here today.
That's a separate form of litigation.
But I think
I'm sustaining the objection.
All right, thank you, Your Honor. Your Honor, then may I have a 15-minute recess?
Yes, we'll do that.
Thank you, Your Honor.
Okay. Any other matters that you wish to bring to the attention of the court before we deal with it, so I can give you a homework assignment for that 15 minutes?
No, Your Honor.
Wilton land records are online.
Oh.
You have to register. You need a password and ID. So that information would be obtainable. The amount of the mortgage payoff would not be obtainable, but there was no foreclosure. So the chances are likely that that mortgage had been taken out in 2015. The principal had been paid down somewhat. I have no idea whether it's a 30-year mortgage, but assuming it's a 30-year mortgage, you don't divide the mortgage by 30 because most of the payments in the first 5 years are total interest. So there's very little pay down there, but this is a 10-year mortgage, so there'd be some pay down. You could approximate.
All right, thank you, Your Honor.
Okay. Thank you. 15 minutes. You would take a break. Someone who's not there.
Sometimes it's a lot easier.
Yes, that's right.
We're on the record, Your Honor.
All right. Your Honor, I have to go check
Thank you.
and see why my clients are not on the screen. Would you bear with me one moment?
Thank you. Just go off the line, make a call. Thank you.
I think we have the back now, Your Honor.
Thank you. We're on the record. You may continue examination, Mr. Mulvey, of Mr. Wilson.
Thank you, Your Honor. Mr. Wilson, what year did you sell Chief Spring Road?
I believe it was 2024.
2024.
Yes.
Okay. And who did you sell it to?
I cannot pronounce, neither can I pronounce nor spell their names.
Okay. What was it? An Indian couple?
I believe that they were of Indian heritage, but I'm not exactly sure.
Okay. According to the assessor's card in the town of Wilton, the sales price was $800,000. Does that sound correct to you?
Are you asking me?
Again, if you're asking me, again, I don't have the figures in front of me,
Okay.
sir. I cannot respond to you.
So you sold a house a couple of years ago, and you don't have any personal recollection today as to the sales price of the house.
No, I don't. It was something I prefer forgetting. No disrespect to you or to the court. It was a very aversive experience, and I will leave it at that. There is a source, perhaps you can help me or the court can help me determine the exact numbers. But at this particular point, I cannot answer you.
Okay. When you sold the house, who received the proceeds from the sale?
After course, it would have been my wife and myself.
Okay. And I don't mean to beat a dead horse, but this hasn't helped you recall approximately a range of what you received as your net from the sale of the house?
No, sir. What I do recollect was that a condition of the sale of the home was based on giving the buyer an allowance for a roof, some asbestos remediation in the crawl space, and a water issue in the basement.
And how many years did you own Chief Spring Road?
I'm going to say approximately 6.
6? Okay. Do you remember what you paid for the house?
No, I do not.
Do you have a guess at, well, not a guess, but could you give me an estimate of what you think you paid for it?
Sir, again, I'm not going to, I really can't do that, sir. I don't know.
Okay, how much did you pay for the house you're currently residing in?
Well, I'm going to object, Your Honor, to that as relevance. It was purchased in 1972 was the prior testimony.
Thank you, sustained.
Okay. Do you have any knowledge of what your current home is appraised at?
I have absolutely no idea.
Do you have any knowledge of what the town has its value listed at with the assessor?
I'd have to look at past tax documents.
So it's your testimony, you don't know.
No, I don't.
Mr. Mulvey, are you interested in the numbers?
No, Your Honor, I'm just trying to establish that the defendant has a very selective memory.
Yes, that's okay. I'm not going to interfere with it, but by giving you a number. Continue on.
All right. Now,
But
I have
I will-
nothing further, Your Honor, of this witness.
Okay. My information is that the town of Wilton has hired a company called COTT Systems, COTT Systems. And when you go online, they say that they have their records online. When you go online to the Wilton town clerk's office for the purpose of getting the access, you're referred to a COTT Systems website in which you must enter your password and your ID. I've not done so. I'm not requiring you to do so. But every so often, information that is a public entity that requires a password and an ID is furnished on a public basis without an access or ID. And in fact, the COTT Systems was able to publish 24 pages of material for transfer report from January 1st, 2024 through December 31, 2024. I have page 1 of that transfer report before me, and it indicates the grantor is Edward and Mary Jane Wilson, and that the property is 157 Cheese Spring Road. And there's a number attached to it that's different than what Mr. Wilson has indicated. Okay, indicates that the book and page is recorded. The names of the purchasers are difficult to pronounce, but are each has 3 names. And the closing date was January 17th, 2024. Sale price was $890,000. I'm proposing I take judicial notice of the $890,000 sale price on January 17th, 2024 of 157 Cheese Spring Road. I will not do so until you've had an opportunity to go check the Wilton land records to verify that information. I do not have a book and page or other verification of it. I just have it on my screen right now.
Your Honor, if I may inquire,
Yes,
judicial notice is an evidentiary offer
yes.
to which either party may object. My
And not only
question-
that, excuse me, not only do you have the right to object, you have a hearing to be held on it.
I do, but
That's correct.
But I
And
don't. I'm
I
not
always
making-
get, I give the right to object, and I give a hearing. And I tell you, a blank stare goes across the lawyers in the room because they've never participated in a judicial notice hearing, and I conduct them on a regular basis.
Well, actually, I have.
I have a somewhat rookie clerk sitting here, and he acknowledges yes, so he must have seen me do it a couple of times already.
Well, my point
Okay.
being this, Your Honor, my objection is taking judicial notice of the sales price without knowing the disbursements may be prejudicial.
Of course, I understand that, but there was testimony that was $800,000 as the sales price. It appears that 890 is the proper sales price. The testimony before the court, the only evidence before this court is 800,000. There is no testimony, there is no evidence of an 890,000, but I'm indicating that there is a COT systems availability. And that's sufficient for a court to take judicial notice of that, but I need to have a hearing on it. I need you to verify that information. I'm just telling you. That's it. I don't know how I got it.
Well, I would ask for it.
I
then, Your
went, I
Honor.
went to the website for the purpose of accessing the documents. And it required me to enter a password and ID. I didn't do so. So I just checked it again, and all of a sudden this paper came up.
So, Your Honor, I'm not looking to make this a cause celeb. I think Your Honor recognizes that $890,000 gross sales price could mean that the Wilsons walked away with nothing, walked away with something, but what you don't know is what they walked away with.
Yes, that's correct. I agree. I agree with that. I agree. I know that the what the mortgage was. I know the date of the mortgage. I'm assuming a pay down for a 30-year mortgage, and the pay down would reduce that principal amount, that there was no foreclosure. I've checked that to see that there is no foreclosure, and therefore there would be some cash that would be available at $800,000 or at $890,000 for net proceeds, but I have no idea what it is, and I have no way of knowing what paybacks to the buyer were made out of that, either $800,000 or $890,000. I have no idea what that is.
Nor does the court know
anything. Nor do I know of any other claims that may have been made, such as mechanics liens and things of that nature that have been on the property, for which there would be no foreclosure, or liens or mortgages that would be placed on the property for which there was no foreclosure. That would be second mortgages that have to be paid off. I don't know the brokerage commission, so there's lots of things that I do not know about the net. But I'm trying to
equally importantly, Your Honor, there was, as you alluded to earlier, since you reviewed all of the related cases, there was a civil claim filed by Mr. Lindenthal, and
yes.
You don't know how much, if anything, Mr. Lindenthal extracted from that sale.
That's correct. That is absolutely correct. But I'm trying to shortcut this matter so that we have a hearing that is a reasonable amount of time. We're over a small amount of attorney's fees, and it's not to need to have a couple of days hearing and all sorts of formal evidence and all the rest of it. I'm trying to shortcut it. Evidence before the court is that the gross sales price 800,000, the 890. It's blowing in the wind, but it's COT systems that started the wind. Okay. Right.
Understood, Your Honor. Did I
Thank you.
understand Mr. Mulvey to say that he was passing the witness?
Mr. Mulvey,
I'm sorry,
you
I
have the,
didn't hear that. I'm sorry. I
you have
apologize.
you have the next question, please.
I think he said he was passing the witness, but I could be wrong.
Any further questions, Mr. Mulvey?
No, Your Honor.
Thank you. Redirect, please.
No redirect, Your Honor. Thank you.
Thank you very much. Okay, Mr. Wilson has completed his testimony. Mr. You have any other witnesses to call?
Yes, Your Honor. I'm going to call Mary Jane Wilson.
Thank you.
And please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case will be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Can you please state your name, spell your last name, and state your address for the record?
Mary Jane, Jayne, Wilson, Wilson, 12 Pleasant Street, Darien, Connecticut.
Thank you. Thank you. You may have a seat, please. Mr. Collins.
Thank you, Your Honor. Ms. Wilson, this is an impolite question, but I must ask it nonetheless. How old are you?
Oh, I'm going to be 79 in 4 weeks.
Okay. And are you presently employed, ma'am?
No.
Okay. Do you have any source of income?
Yes. My Connecticut pension
Okay.
and my Social Security.
And when you were employed, to achieve a Connecticut pension, what were you employed as?
A school counselor,
And when did you last have such employment?
2013.
Okay, so roughly 12 or 13 years ago. Is that a fair statement, ma'am?
Yes, sir.
So how much is your Social Security on a monthly basis? How much do you receive?
Well, because I was a state employee under the Federal Windfall Elimination Act, I only got $127. And then last year it was overturned and I got $1,200. But
Okay,
it's being overturned again, so I'm getting less in February. I've
Okay.
never gotten regular Social Security.
understood. And how much is your state of Connecticut pension on a monthly basis?
$3,000, and I pay $880 in medical insurance per
Okay.
month.
So the net of that would be about $2,100, ma'am?
24, 25, yes.
Okay, and then you pay taxes on that?
Yes, I do.
Okay. So you've heard testimony here today, and His Honor Judge Tierney learned that the property sold for $890,000. Do you recall that, ma'am?
Hey, the only evidence is Mr. Wilson's testimony of 900,000. I'm not.
Well, actually, Your Honor, I don't think Mr. Wilson ever testified to the sales price. I think Mr. Mulvey did.
I think he said 800.
Did he? All right.
Yeah. I think he said 800.
Okay.
I don't want to fault Mr. Wilson's recollection. I don't want to deal with anything. I'm just indicating that we have a source of it for the internet that would be capable of shortcutting the evidence portion of the trial, and it indicated that. So
Okay. Here's my question.
you can explain to your clients that I'm perfectly capable of taking evidence before the court that is inadmissible, hearing it, and then discounting it and not paying any attention to it because it's inadmissible. All right? You
Yes.
understand judges do that.
Okay.
Lay people don't understand that, but you both of you as experienced lawyers know that to be a fact.
Okay. So
Thank you.
I understand, Your Honor. So, Ms. Wilson, do you have an independent recollection as to the sales price of the Cheese Spring property?
No, I don't.
Okay. However, was that mortgage, which was in the original principal amount of $545,000, was that paid off at the time of closing?
I assume it was, yes.
Okay. Did you have legal fees?
Yes, we did.
Okay. Did you have to pay a real estate broker?
$40,000.
$40,000. And did you have to give credits back to the buyers?
Yes, we did.
Do you know how much the credits were?
I don't know, but it was a substantial amount because it was like the roof and a couple of other, Eddie knew more about that than I did.
Okay. And when you say Eddie, you mean your husband sitting next to you?
Yes, I'm sorry, Mr. Wilson.
Okay. And so did you have to make any repairs to the property to put it in saleable condition?
Definitely.
You know how much you spent on those repairs?
I would say about, now, when I go through the whole thing, the repairs were well over $100,000.
Okay. And did you pay for them pre-closing in some fashion? In other words, before you closed with the buyers, had you already made those repairs at your expense?
Yes.
Okay. And then did you borrow money to do that, or how did you pay the $100,000 plus?
Oh, we made loans, and for the first time we took credit card. We used our credit card, but people were very nice. Like, one of our lawyers did not take money until the house was paid, until the property was sold. The landscaper was $800 a month, and he was very nice. He saw how everybody felt kind of sorry for us, and a lot of these were at, until we sold the property, we had to pay people.
Okay,
And we
but
also, I did not put in the fact that one patio was, it was all disrupted. I mean, it was a danger site, so we had to do a lot of landscaping. Landscaping must have been about $45,000.
Okay, and is that in addition to the 100,000 you testified?
It certainly is. It certainly is, Mr. Collins.
And you heard me refer to the civil claim by Mr. Lindenthal. Was he paid a settlement once the house sold?
Yes, we paid him $18,000 or $20,000.
Okay,
And that was also to his $5,000 was to his lawyer.
okay, so in addition to the 18 to 20,000?
$5,000. I don't know if it was included or in addition. I forgot, but we had to pay Mr. Harrington, his lawyer.
Okay, and with regard to, I'm not gonna row the same row as I did earlier. All my questions about your daughter and the grandchildren living with you that I asked of Mr. Wilson about you folks supporting them and everything, do you agree with and adopt all of his testimony as to what you folks do for them?
Definitely, but I could do the food bill.
You can tell us how much the food bill is?
Yes.
Okay, well, whatever it is, tell us what it is.
Well, if we put going out to eat and whatever other expenses, it would be almost as close as $1,400 a month.
Okay, and lost my train of thought.
I could tell you what she contributes to that.
How you mean, Melissa?
Mm-hmm.
How much did she contribute?
$200 to $300 a month.
Okay, all right. And again, I'm going to take all the answers Mr. Wilson gave and try to not cover the same territory with you.
Thank you.
The taxes. Mr. Wilson alluded to taxes from the sale of the property. Is that correct?
Yes,
Did the sale of the property result in a tax liability to you and Mr. Wilson?
definitely.
Was that a capital gains tax liability?
I don't know.
My question is, was it a tax on the profit on the sale of the property?
I guess so. I don't know. Yes,
Okay.
yes.
Have
Yes.
you paid off all those taxes that relate to
No,
the
absolutely not. We pay them off each month. I think it's about $800 to $1,000
And quarterly.
and quarterly. I'm sorry, quarterly. And now we have to pay in January, $8,000.
Okay, so you were on an installment plan with the taxing authorities because of capital
Yes.
gains taxes on this
Yes.
property? Okay.
Yes,
And by the way, was there a substantial amount due at closing for real property taxes which were due on the property?
I assume so, yes.
Okay, you're not sure. Okay,
There were a lot of checks written out.
okay. Would you say you got a lot of money from the sale of this property?
Absolutely not.
And you're still
Absolutely
paying,
not.
and you're still paying taxes?
We're still paying for that, everything.
Okay, all right. Your Honor, I have nothing further of this witness.
Thank you. Mr. Mulvey?
Mr. Mulvey, you are muted.
Sorry. Mrs. Wilson, do you have a personal knowledge of what the Chief Spring property sold for?
I'm going to say what my husband said. The honest truth was, it was such a horrendous experience. I don't know if we made $1 million. I don't know if we made $1. We put it out of our minds. So I don't know what they sold for. If he says 900, if you would say $1, we don't, forget it. We
Do
just
you know-
didn't care.
All right, do you know how much money you received from the sale of the property?
I'm going to
Whatever-
object to the form of the question insofar as I don't know if Mr. Mulvey's asking after the payment of all those things that we discussed earlier or before the payment of those things we discussed earlier.
Well, the question is, do you know what the net money given to you was after the sale of the property?
I will answer it this way. We owed a substantial amount of money. The real estate took $40,000. The electric guy, the electrician, took $21,000 because we owed it on the heating and electricity. The landscaper, we owed money to. The credit cards we owed money to. A lot of people felt sorry for us, like I said, even the lawyer, I don't want to mention his name, but he didn't take money
Your Honor,
from
at this
us.
juncture, I ask that the response be stricken. It's non-responsive to the question.
I would disagree,
You
Your
asked the
Honor.
question, the answer will stand.
Thank you.
I mean, people just felt sorry for us, and they said after we sold it, they took repairs. And again, a lawyer was very nice. He took the money after we sold it. We couldn't afford that much, keeping that much of credit cards we had to pay, car payments we had to pay. I mean, it was astronomical. I don't know. I don't think Eddie and I mean, I don't know. You want to say we made $1, fine. We did not profit highly from this. It did not change our lives in any way, believe me.
Okay, Ms. Wilson, what bank accounts do you have?
We have 2 bank accounts.
No, let me ask the question more exactly. I'm only asking about you, not you and your husband, okay?
My husband and I have the same bank accounts, the same everything. We're married 56 years. Everything is together.
So all your accounts are joint?
Exactly.
Okay, so then where do you have bank accounts at present in your name?
M&T and only M&T.
Okay, and which accounts do you have at M&T?
We have 3, a bank book, a checking account, which is really our bills, and then like another checking account, a debit card that I use for food or gas or something like that. So there are 3 accounts at M&T.
Okay, so as to the first account, do you have any personal knowledge of how much money is in that today?
Well, the bank account has about $9,000, maybe 93 maybe.
Okay, in the checking account, do you know how much is in that?
No, I really don't. Whatever he said, I don't know.
Okay.
My debit account has about $300 in it.
Uh-huh. Do you have any interest in any annuities?
The only thing that I would say is, we do own Apple stock, and I used to get $250 4 times a year. And yesterday I got the accounting of it, and it has 0 amount of dollars in that. I just got it last night. It's on my table, and Eddie and I laughed. So that's my annuities. I have 0 as of 25-26.
Okay, well, how much Apple stock do you own?
I have no idea. I would say anywhere from 50 to 60, but that's a guess. That's a guess, because I think it doubled, that kind of thing. I forgot what they call that.
All right. Do you remember when you purchased the stock?
Absolutely not. It was before Cheese Spring, if that's what you're alluding to.
Okay, and do you recall the price of the stock?
Absolutely not.
Do you have any life insurance?
I think I have somewhat with the Stamford Board of Ed, but it's like $16,000, something like that. Very little life insurance. I think I have 1.
Do you know if it's whole life or term life?
Again, you clarified that for Eddie. I have no idea.
Okay, do you know what its cash value would be upon surrender?
Well, Your Honor, that presumes it's
I
a
think-
whole or universal. Hold on. I'm objecting. It presumes
She
it's
can
a whole.
answer, she can answer the question if she understands those terms.
I don't fully understand. I think it's 16,000 if I die, or I don't know. That's what I think. I don't know. I wouldn't swear by that money.
Okay, and do you know if that policy is paid up, or can you
No,
continue to
nothing.
pay?
No, we pay it every month.
And what is that fee?
Again, my husband pays that. I would say maybe 170, but I'm taking a guess.
Okay, so that would it be correct then to say you just don't know?
Probably, yeah.
Okay. do you have any real estate holdings in your own name outside of the state of Connecticut?
No, not in my own name. Eddie and I again own that timeshare, which is a clunker.
On the table, though, Attorney Mulvey.
Well, if you'd like to buy it as part of, or be given as part of your, fees, that might be a reasonable solution for your clients.
We're offering it to you.
And actually, we did try to get rid of it, but nobody wants it.
Okay. Are you aware of the amount of the judgment in this case that was entered against you and your husband?
No.
No. So you don't know how much money my client is asking to be paid. Is that
Oh,
correct?
yes, I do. I didn't know what a judgment meant. $12,000.
Okay. Can you tell me, do you think, can you give me an estimate when you think you could pay that judgment?
I'm going to object, Your Honor. This would be settlement discussions.
Overruled. Ms. Wilson, you are not, if there is any settlement discussions and the numbers have been discussed, that is not, you're not to give that as an answer. With that understanding, you may answer the question.
Would you rephrase the question or just ask it again?
Sure. Let me go back. My first question was, were you aware of the amount of the money judgment that entered against you by my client against you and your good husband? And I think you answered yes.
$12,000.
Okay. And my follow-up question was, can you tell me when you think you can pay that judgment?
Ay. As long as possible. That we're there, as long as we're alive. I mean, I don't know what to say. We're
Okay.
both almost 80.
You were here for your husband's testimony, correct?
Pardon me?
You were here, you were present when your husband
yes,
testified.
yes.
Okay. And your basic testimony is that if I'm understanding it correctly, you're sort of asserting the claim that your monthly expenses exceed your monthly income. Is that correct?
Yeah, sometimes they do. Yes, sometimes we do. Yes, they do.
Then, are you any time then planning to file bankruptcy?
No, absolutely not. We're not that type of people.
Okay,
No.
so why won't you file bankruptcy?
Because we wouldn't
Objection,
do
Your
that to
Honor.
our
That
credit.
calls, hold on. That calls for a legal conclusion.
No, it isn't. It's argumentative, sustained.
All right. So, ma'am, can you give me a rough estimate as what you believe is your monthly income?
Your Honor, there's been testimony on this, asked and answered.
Sustained.
All right, and then can you give me your best guess as to what your average monthly expenses are?
Okay. You want the expenses this month? We owe 18,000. Yes.
Yeah, well, yes.
We owe
No, I said
8,000.
average monthly expenses. I didn't say the expenses for
No,
this month.
no, Mr. Mulvey, you asked the question. She's ready to give an answer.
$8,000 in property taxes on a house that we did not think we would live in this long, and $8,000 to the federal government because of cheese string. So we have $16,000 this month to pay.
And Connecticut too.
In Connecticut federal taxes. It will be taken out of our bank book or taken out of anything. And
So that's just for this current month, correct?
well, 4 times, well, it's going to happen in June too, because we pay property taxes in June. So it's a couple of times a month. It's a couple of times a year.
Mhm. Do you recall what your expenses were for November of 2025?
Anywhere from $10,000 to $15,000, depending on insurance doing or anything expenses like that. And we also got a roof we had to buy for $14,000. It was really 17, but we gave them $3,000, and now we have a loan of $14,000 with Wells Fargo for a roof on our house that we didn't expect to live in.
Okay. Ma'am, when do you recall you were first made aware that my client had a money judgment against you? Do you recall?
Absolutely not.
No. There was a point in time, though, when you realized that my client had obtained a money judgment against you, correct?
I would assume so.
Yes. Okay. Since that time, have you and your husband had any discussions about how you were going to pay the judgment?
I'm going to object, Your Honor, to the extent that any of those discussions involved me as their legal counsel.
What's the purpose?
I'm
of
not
the
asking
counsel?
for any discussions with counsel, just discussions between her and her husband themselves.
Relevant, Your Honor.
Overruled. You may answer the question, Ms. Wilson.
The question again, please.
Mr. Mulvey, re-ask the question, please.
Oh, okay. After whatever time that was that you realized that my client had obtained a money judgment against you, have you and your husband had any discussions outside of your legal counsel, just between yourselves alone, as to how you intended to pay the judgment?
Yes.
Okay. And what was the result of those discussions?
There was no result. We just got her bill and we talked to her. Did not do dollars and cents. It was over our heads.
All right. Did you have any intention of paying the judgment?
From object, Your
Eventually,
Honor,
I don't know. What was
speculation, objection, speculation.
I claim it, Your Honor. It's just a simple question of whether what her intent is, and she knows her intent.
It's not relevant for these purposes, Your Honor.
I've sustained the objection.
All right.
Thank you.
I have nothing further, Your Honor.
No redirect, Your Honor.
Thank you very much. Mr. Collins, any further witnesses or documents or evidence in this
No, Your Honor.
prosecution of the motions?
No,
So
Your Honor.
you're resting on those two motions that we had to discuss, 125 and 126, correct?
Yes, Your Honor.
Mr. Mulvey,
Nothing further, Your Honor.
thank you. Matter is submitted to me. There's no need for any oral argument. There's no need for any brief. If you wish oral argument or you wish a brief, please so state.
Your Honor, I don't request any oral argument. The only thing I would say is that in my 40, well, I guess this would be oral arguments.
Mr. Mulvey, listen very carefully for a non-oral argument statement.
I would say that what we are respectfully requesting here, Your Honor, is the order of $35 a week. This is not without precedent with Your Honor. And I know every case is a snowflake, as I like to say. In my 42 years, I've pursued litigation to collect fees maybe twice, maybe three times at the most. In the matter of Collins versus Odetta Rogers Clark, FST CV 16602-8664S.
Why give me the docket number? Don't you think that I remember that docket number?
Well, actually, it would not surprise me, Your Honor. And
I know about the case. I know about the case.
Okay, so Your Honor entered the $35 order on a $33,000 fee at 4% interest. This is a substantially less, and Attorney Latarullo had been paid substantial amounts prior to this. So it's not like she has been unpaid. I think that the presentation we gave today is, and it's no fault of Attorney Latarullo's, that Dan Lindenthal did the things that he did to this family, and they continue to suffer from it. But I would respectfully suggest that, Your Honor, in light of all the circumstances mentioned today, that Your Honor have, well, I can't use a better word, some level of mercy on them so that they can try to climb out of this situation, which should never be imposed on someone at this point in their lives. You don't get to be 80 and see yourself raising a couple of small kids and all that. So I just asked the court to take the equities into account and consider what Your Honor did in the Collins versus Odetta Rogers Clark case.
Mr. Mulvey?
Your Honor, I would just urge the court to think that, my client, prosecuted this case. There really was no movement by the defendants to do anything until after the judgment entered. There's no question that they owe the funds. I've known my client for a long time. I can't remember another time when they had engaged in litigation to collect their fees. It's not an unsubstantial amount of money owed to my client. It has had a negative impact on my client, who was relying on these fees to pay their own overhead and costs as it goes to the equity. The other thing is the burden is proving what their expenses are, and they only did it on their own self-serving testimony. I don't have any documentation. I don't have any, there weren't any financial affidavits. There were no tax returns. There was no delineation of it. And through the testimony, I think the court heard that they had a very clear recollection of what they paid out. They have a very poor recollection of what comes in, which go to the credibility of their testimony, which the court is the ultimate arbitrator of that. So, they have basically put up a Stalingrad defense to deny and avoid paying this matter. There's been multiple motions filed. There's no question that the debt isn't owed. I would ask the court to put in a reasonable order that the case law indicate that has to be done serving both parties. And obviously that type of order can always be brought back for modification under the way our case law reads. So, for that purposes, Your Honor, I think my client has been more than reasonable and trying to get this. And I just ask the court that they take the totality of all this and the harms to both parties. I mean, these are people who claim to be destitute, who are living in a nice house in Darien, Connecticut. That hardly seems to be, a tremendous hardship. So that is the plaintiff's position.
Okay, anything further from either counsel?
Your Honor, I think that if Your Honor looks at the law of the case, if you will, the motions that we filed previously, it shows that Attorney Lattarulo was paid a very substantial amount of money in this matter. And so I know that Attorney Mulvey is saying she can't pay her rent over this, what amounts to like $6,700 after you add on the interest that was in the retainer agreement and Attorney Mulvey's fees. It's really $6,700. That's the claim. And the law of the case will show, Your Honor, that she was paid a substantial amount. So we're not here because we're not contesting the amount because we let it go to judgment, but we are saying that the equities here strongly favor the Wilsons because of their current circumstances. And we ask that the court take that into consideration. And as I said, consider how much Attorney Lattarulo was paid, which we're not contesting that she earned it, but we are suggesting that the court consider that she was paid it.
Okay, thank you. That concludes the hearing.
Your Honor, can I just respond briefly?
No, you may not.
All right.
No, that concludes the hearing. I have 120 days to render a written decision. There will be a written decision in the interim period of time. The three motions that were assigned for hearing today were 119, 125, and 126. We have concluded the matter for 119. The clerk has been instructed to enter an order of 119 identical to the order Judge Lee entered on 120.01, and that concludes that matter. There will be nothing further concerning 119. On 125 and 126, I have entered an order of stay on September 19th, 2025. On both of those motions, 125 and 126, the stay says no further efforts for the collection or enforcement of this judgment will occur until the conclusion of that statutory hearing. In my opinion, the conclusion of that statutory hearing could be a vague termination date, and the court wishes to interpret that particular phrase to mean that the conclusion of the hearing is the rendering of a decision by me at the end of that hearing, and therefore the stay remains in effect. The September 19th, 2025 stay and 125 and 126 remains in effect until the court issues its written memorandum of decision.
That concludes
the
Your Honor?
hearing.
Thank you,
On a
Your
si-
Honor.
On a side note, does anyone have any idea what the calculation of that 120 days would be?
My understanding it's from the time the clerk sends the notice out.
No, can you count, assume today is the day, and you start counting 120 days.
We would be very, very close to March or past it, where Your Honor is going to take another avenue.
Thank you very much. You have a full understanding of it. Mr. Collins, do you have a full understanding of what Mr. Mulvey has indicated?
Actually, I was doing the calculations, so I did miss what he had said.
I haven't put in for reappointment with the governor.
Oh, that I
My-
do know.
my-
That's
yeah, my last day is the end of March, so that's less than 120 days. Have no fear. It'll be done in written format in an appropriate period of time
Thank you, Your Honor.
prior to
Thank-
well before my retirement. Thank you
Thank
very
you,
much.
Your Honor.
Okay.
Thank you.
Thank you,
and,
Your Honor. Have a good
and,
day. Joe, take care.
Thank you, Your Honor.
Two of you have appeared before me virtually for my entire judicial career. So personal thanks to both of you.
Oh, I thought you were
Thanks
asking
to Your
for an
Honor.
apology.
Thank you. Yes. Thank you.
Thank you, Your Honor.
Thank you, Your
Thank you.
Honor.
That concludes the matter.
Bye.
Thank you. Bye.